Good evening, everyone. My name is Arthur F. Gilloon, and I'm a proud board member and Vice President of Dubuque County Right to Life. Today is December 2nd, 2021, and we're here to talk about the oral arguments in the case of Dobbs versus Jackson Women's, Jackson Women's Health Organization et al. In the United States Supreme Court in Washington, D.C. A quick little thing about me. I'm in my 44th year as a lawyer. I'm a graduate of the University of Notre Dame in 1975, Iowa Law School in 1978, and I practiced here in the tri-state area since that time. I was a prosecutor in the Dubuque County Attorney's Office for a period of time and then in private practice since then. I'm licensed in Iowa and Wisconsin and before the Iowa Supreme Court, the federal courts in Iowa, and the 8th Circuit Court, and also licensed to practice before the United States Supreme Court, which is the subject of our program tonight. And tonight we want to talk about as I said, the oral argument that took place yesterday in Washington, D.C. So let's jump right into it. Yesterday, the Attorney General for the state of Mississippi said this to the 9 justices of the United States Supreme Court. I have a picture of them right here. So there they are. And we're going to talk about their participation in this oral argument and what all of that means. I'll leave that there for now. But here's what he said. Mr. Chief Justice, may it please the court. Roe versus Wade and Planned Parenthood versus Casey haunt our country. They have no basis in the Constitution. They have no home in our history or traditions. They've damaged the democratic process. They've poisoned the law. They've choked off compromise. For 50 years, they've kept this court at the center of a political battle that can never resolve. And 50 years on, they stand alone. Nowhere else does this court recognize a right to end a human life. Consider this case. The Mississippi law here prohibits abortions after 15 weeks. The law includes robust exceptions for a woman's life and health. It leaves months to obtain an abortion. Yet the courts below struck the law down. It didn't matter that the law applied, that the law applies when an unborn child is undeniably human, when risks to the women surge, and when the common abortion procedure is brutal. The lower courts held that because the law prohibits abortions before viability, it is unconstitutional no matter what. Roe and Casey's core holding, according to these courts, is that people can protect an unborn girl's life when she just barely can survive outside the womb, but not any earlier when she needs a little more help. That is the world under Roe and Casey. That is not the world the Constitution promises. The Constitution places its trust in the people. On hard issue after hard issue, the people make this country work. Abortion is a hard issue. It demands the best from all of us, not a judgment by just a few of us. When an issue affects everyone and when the Constitution does not take sides on it, it belongs to the people. Roe and Casey have failed, but the people, if given the chance, will succeed. This court should overrule Roe and Casey and uphold the state's law. That was the opening statement yesterday of Mr. Stewart, whose first name is, Scott Stewart. He's a 39-year-old Attorney General of the state of Mississippi. So the way oral arguments goes, he got to go first. What I want to talk about now is, how did we get there, to that moment in history? And I've given you a little handout here as part of the program, and I just want to run down a little bit of how we got there from 1973 forward. Most of you have heard of Roe v. Wade, some have not heard of Doe versus Bolton, but in 1973, those were the companion cases that legalized abortion on demand in this country. One of the great fallacies that has lived in the law and among lawyers is that we have not had abortion on demand up till birth for the last 50 years. I will tell you that is what we've had. And any legal opinion or person that tries to tell you we've had anything less than that is wrong, and here's why. Roe versus Wade arbitrarily separated pregnancy into 3 trimesters. There is no medical separation in a trimester. There's developmental separations that happen at 6 weeks, at 10 weeks, and so forth as the human unborn baby develops. But there's no magic that occurs at the end of the first trimester. This is a judicially created concept. So what Roe versus Wade said was, in the first trimester, no state can restrict abortion. In the second trimester, states can restrict and make laws about abortion, can't restrict, can regulate abortion to protect the life or health of the woman or the baby. In the third trimester, after viability, whenever that is, and that's a moving target, as we all know. That is when the child becomes able to live outside the womb, which Roe pegged at about 24 weeks. Then they said the state could prohibit abortion. And all the media hung their hat on those words, prohibit abortion. In the companion case of Doe versus Bolton, however, the Supreme Court adopted the World Health Organization's definition of health to include both physical and mental health, including psychological stress. So since Roe, up till now, up to the moment of birth, a woman who wants to have an abortion can, if the doctor is willing, perform an abortion up to the moment of birth, anywhere in this country, in any state, and not violate Roe. And any state law that prohibits that abortion, if it's necessary to preserve the life or health with that expanded definition I just referred to, is unconstitutional. People don't realize that. So we've had all this discussion about partial birth abortion and pre-viability and post-viability. People need to understand today and for the last almost 50 years, abortion on demand has been legal in this country and a few other countries around the world. Communist China, North Korea, there's the Deadly Seven as they're called. So that was the law of the land and has been the law of the land. Now, as shown on your handout there, in 1992, after a series of cases, a case came before the Supreme Court. Casey was the governor of Pennsylvania. So Planned Parenthood, which is always the culprit here, always the one who's pushing the pro-abortion agenda, Planned Parenthood versus Casey, the state of Pennsylvania had 4 parts to a law: 24-hour waiting period, informed consent, parental notification, all pre-viability. All these were going to be before 24 weeks, so that's why it became such a hot-button case. They also had a spousal consent portion of that was eventually struck down. What Casey did was Casey, throughout this trimester standard, upheld Roe and said, we're going to use a viability standard and an undue burden test. So if you're going to put in pre-viability standards, such as if a woman wants to have an abortion, we're going to say you have a 24-hour waiting period. If a woman wants to have an abortion, we're going to make sure that she gets handed paper about informed consent, about at what stage her baby is at what abortion, what the risks are, that you might die, that you could be harmed, that you might be sterilized, all these things that a lot of women don't know. And then also, if it was a minor, parental consent or parental notification had to be involved, and there was also a judicial bypass. So for a child who was going to be subject to abuse, they could go to a judge and not have to inform the parents. So the big thing in Casey was they actually upheld all those parts of the law under what was called an undue burden test. The test was it unduly burdensome of this right to have an abortion, to have 24-hour notice, or wait 24 hours, or be informed, handed a piece of paper and be informed of what the risks were for the abortion, or if it was a minor, to have the parents know about it before it occurred. And the Supreme Court, in a divided opinion, said those are okay. But what happened was, and again remember, they said those are okay, but they didn't overrule Roe. So we still had abortion on demand, but in Pennsylvania, informed consent, 24-hour waiting period, minors had to have parental notification or a judicial bypass. Okay, so that was the law in Pennsylvania. So other states tried to do the same thing, and then we had from 1992 all the way through for the next 2 decades, everyone trying to do this. And the test became, and the Supreme Court ruled in Casey, that those rules didn't unduly burden a woman's constitutional right from Roe to have an abortion. Why? Because it doesn't stop the abortion. 24 hours is not, unless it's an emergency, doesn't stop the abortion. And parental notification doesn't stop the abortion. So they were burdens, but they were not undue. The state had an interest in protecting life, the court ruled. Now, Justice Thomas, who's now the longest serving Supreme Court justice, he dissented in that case, and he would have used Casey as an opportunity to overrule Roe. So think about that. 1992 to almost 2022. So some would say he's been waiting, what, 30 years?
Yeah.
30 years to have this happen. So that's the gist of where we got to 1992. So between 1992 and today, all sorts of states have tried to work with Casey. So they've done restrictions on abortion before viability. They've done abortion clinics had to be regulated. They have to have hospital privileges. They have to have doctors there. All these things, and all these cases have been in a big mess because it's so fact specific. What is the burden in this particular case? And the courses look at, well, where's the nearest abortion clinic? How far does the woman have to travel? What's the average cost of an abortion in that state? So you can imagine you have judges all over the country trying to figure out what an undue burden is. That's not defined in the Constitution. And so part of what brought us to oral arguments yesterday is Roe and Casey have created a judicial mess. That is what Scott Stewart's talking about. There's no standard, there's no nothing, and that's some of the proof of the unconstitutionality of Roe and why it should be overturned. So let's fast forward to 2018. What happens in 2018? Mississippi passes the the Gestational Age Act, and they say we're going to regulate and prescribe abortion after 15 weeks. And that law passes. And it works its way through the federal courts, ends up in front of the Supreme Court, and the argument is, well, this law is unconstitutional under Roe. Because Roe said, number one, abortion on demand, which you'll never hear in these arguments, but that's the law. But Roe had said post-viability, remember the third trimester, you can prohibit except to preserve the life or health of the mother or the woman. So the legal issue before the court yesterday was, what do we do? Mississippi is here saying Roe should be overturned because it is a mess. Roe and Casey, as described on your handout, have created a mess, a judicial mess that's unworkable. And the reason it's unworkable is because Roe was poorly decided. There's no constitutional basis for the right to abortion in Roe versus Wade. There's no constitutional basis for a so-called right to privacy. And some of the cases that go back and forth are the ones you've all heard about. The right to abortion really grew out of a case called Griswold versus Connecticut, which had to do with contraception. And then down through the years, that right to privacy became a right to control a person's body and those kinds of things. So a woman's right to control her own body at the expense of her unborn child. So you heard what Scott Stewart, pardon me. Now let's hear what the attorney for the Mississippi abortion folks said. And so the person making this argument is Julie Rickleman. And Julie Rickleman actually is a immigrant to the United States when she was 6. She came here with her family and fled Ukraine. And she is an attorney with the Center for Reproductive Rights, because as you may know, in all these abortion cases, the Jackson Women's Health Organization, which I understand is the only abortion chamber in the state of Mississippi currently functioning, they couldn't do this on their own. So they become sort of a voluntary pawn in the game of the Center for Reproductive Rights and all these national pro-abortion organizations and legal organizations that fight these cases. They finance them, they fight them, they have the lawyers. And so Julie Rickleman, to her credit, is really kind of a super lawyer. She's 49 years old, and she, let's see where she went to school. Harvard Law graduate. She's argued case. This is her second case arguing before the United States Supreme Court. And for some reason, I thought she had been a clerk too. Yeah, no, she just argued this other abortion case. So you heard Mr. Stewart's opening statement, so here's hers. So she says, Mr. Chief Justice, and may it please the court, Mississippi's ban on abortion 2 months before viability is flatly unconstitutional under decades of precedent. Mississippi asked the court to dismantle this precedent and allow states to force women to remain pregnant and give birth against their will. The court should refuse to do this for at least 3 reasons. First, stare decisis, which is a Latin word, phrase, which just means the thing stands. So a decision should stand, and it's sort of like precedent, but it's sort of a Latin way to say precedent. Stare decisis, the thing is decided, meaning Roe decided it, so why are we arguing about it? Presents an especially high bar here. In Casey, this court carefully examined and rejected every possible reason for overruling Roe, holding that a woman's right to end pregnancy before viability, remember what I said, that's not really the law, was a rule of law and a component of liberty it could not renounce. The question then is not whether Roe should be overturned, but whether Casey was egregiously wrong to adhere to Roe's central holding. Second, Casey and Roe were correct. For a state to take control of a woman's body, demand that she go through pregnancy and childbirth with all the physical risks and life-altering consequences that brings is a fundamental deprivation of her liberty. Preserving a woman's right to make this decision until viability protects her liberty while logically balancing the other interests at stake. Third, eliminating and reducing the right to abortion will propel women backwards. 2 generations have now relied on this right, and 1 out of every 4 women makes the decision to end a pregnancy. Mississippi's ban would particularly hurt women with major health or life change during the course of the pregnancy, poor women who are twice as likely to be delayed in accessing care, and young people or those in contraception who take longer to recognize pregnancy. To avoid profound damage to women's liberty, equality, and the rule of law, the court should affirm. Then the questions start. So Stewart spoke, he got questioned. Rickleman speaks, she gets questions, and I'm going to give you the third one now too. So in the court's oral argument, the defenders of the law get to go first. So Mississippi gets to go first because they're defending their law, and they're the ones appealing the case because they've lost in the lower courts. So the Attorney General for the state of Mississippi gets to go first. Then Ms. Rickleman, representing the other party, the Jackson Women's Health Organization, gets to go second. Then the Biden administration has intervened. So the Biden administration has their lawyer. So when Ms. Rickleman is done, another attorney is going to get up, and her name is, and I hope I'm pronouncing this correctly, her name is Elizabeth Prelagar. And she is a graduate of Emory University and Harvard Law School, and she is a former clerk for Ruth Bader Ginsburg and for Elena Kagan, who's a current member of the U.S. Supreme Court. And what you come to learn in these Supreme Court arguments at this level is everybody kind of knows each other. You know, these are the best of the brightest lawyers arguing all these points. So she's appearing, and of course she knows Justice Kagan. So here's what she says by the time she gets to her stop, and then I'm going to jump back to both of these and tell you what I thought I saw. So when she gets done, then this is Solicitor General Elizabeth B. Prelagar. She says, Mr. Chief Justice, may it please the court. For a half century, this court has correctly recognized that the Constitution protects a woman's fundamental right to decide whether to end a pregnancy before viability. That guarantee that the state cannot force a woman to carry a pregnancy to term and give birth has engendered substantial individual and societal reliance. The real-world effects of overruling Roe and Casey would be severe and swift. Nearly half the states already have or are expected to enact bans on abortion at all stages of pregnancy, many without exceptions for rape or incest. And then I'll go to the end. Women who are unable to travel hundreds of miles to gain access to legal abortion will be required to continue with their pregnancies and give birth with profound effects on their bodies, their health, and the course of their lives. If this court renounces the liberty interests recognized in Roe and reaffirmed in Casey, it would be unprecedented. It would be an unprecedented contraction of individual rights and stark departure from principles of stare decisis. The court has never revoked a right that is so fundamental to so many Americans and so central to their ability to participate fully and equally in society. The court should not overrule this central component of women's liberty. So that's her opening statement, and then they all take questions. So, as you can see on your sheet, the next thing is, so what's going to happen in that third box? Mississippi's law protects unborn babies after 15 weeks. So what's the court do? Overrule Roe, uphold Roe, go with Casey, some sort of viability undue burden test, or some hybrid of that? And so really what we want to know is, what are these folks going to do? because they all have spoken at one point or another. And just to go through, that's Samuel Alito, Justice Kavanaugh, Clarence Thomas, Elena Kagan, Chief Justice Roberts, Neil Gorsuch, Justice Stephen Breyer, Justice Amy Coney Barrett, and Justice Sotomayor. So that's who's on the court. And I think it's sometimes easier to put a face with a name, and then I'm going to tell you some of the interesting things that occur in the oral argument, because that's what this talk is about. So, as you can see in that next box, where the position of the justices, on the right-hand side, Clarence Thomas, his position is well known. As I mentioned, since Casey, and perhaps even before, he has said, Roe's bad constitutional law, it's bad structure, it's bad everything. There's no justification, no constitutional right to privacy or liberty in the Constitution that would justify abortion on demand. So let's talk about the rest. Samuel Alito. He is a longer serving justice than Gorsuch, Kavanaugh, Barrett, and I'm not sure where he falls in with the rest. And so let's see what he asked, because some would say, and I say this without trying to denigrate the court, some would say oral argument, for the most part in any court, can become a dog and pony show. The only reason for that is that for justices whose opinions have been put in writing and are well known, for them it can be an occasion to either publicly ask questions or make statements that strengthen that position or show that they're right, or to for the adverse proponent. In this case, for example, we know that Clarence Thomas wants to overturn Roe, so we're interested in what questions he might ask of the Solicitor General for the United States of America, or Attorney Rickleman for the clinic, or Mr. Stewart for Mississippi. But I want to let's start with Alito, because I have him as possibly being willing to overturn Roe. So when Mr. Stewart is talking, he asks him this. And I have the transcript here, and before I forget, for those who may see this later and for those present here at this little program, you can go on the United States Supreme Court website and put in Dobbs, and they have the audio version of the oral argument, which is just short of 2 hours. And then they also have a transcript, which you can print out and read. And so that's fun and interesting for people to do that if they're interested in that. So, let me find here. Oh, that's 73. Sorry, I couldn't read my own handwriting there. So, Justice Alito, who we would hope would join the pro-life side on this decision, is now talking to Attorney Rickleman, who's the attorney, and she's answering questions now from the justices about her position. So she has taken the position that the common law and the history and tradition of this country is that women have always had the right to end their pregnancy. Well, Alito doesn't believe that, presumably, so he's going to ask her this. He says, well, you just mentioned the common law, and the common law is court-made law. It's a law we generally got from England and our forebears over to this country. And he asked very pointed questions of her, and he wants yes-no answers to confirm in the record of what this is. And his goal is to ask her some questions, because saying, back in the time when you're telling me the history and tradition of all this is that it was legal and sanctioned, and that the country was okay with abortion on demand back in the 1860s, I want to offer you some things that might not make that so. So he says to her, did any state constitutional provision recognize that abortion was a right, liberty, or immunity in 1868 when the 14th Amendment was adopted? Because the pro-abortion lawyer's argument is the 14th Amendment is where this right to liberty and privacy is in the Constitution. And she says, Ms. Rickleman, who's for the clinic, says, no, Your Honor, but it had been allowed under the common law for many years. Well, that's up to debate too. Then he says, does any judicial decision at that time or shortly or immediately after 1868 recognize that abortion was a right, liberty, or immunity? And he says, she says there were state high court decisions shortly before then talking about the ability of women to end pregnancy before quickening. And he says, well, what's your best case? And he's asking her, I think, to offer a case. Well, cite me a case. Well, she doesn't do that. She says, allowing a state to take control of a woman's body and force her to undergo the physical demands, she just goes on to something else. And then he also, then he asks this, and by the way, he refers to a brief for the American Historical Association, says that abortion was not legal before quickening in 26 out of 37 states at the time of the 14th Amendment. Is that correct? And she says, so the answer to that is yes, that's correct. In other words, science at the time, we didn't have what we have now, the 5D pictures that are on everyone's refrigerator. So when the baby moved, that's when they thought there was life. But instead of acknowledging that, the attorney for the abortion chamber says this, that is correct, that abortion was not legal before quickening in 26 of the 37 states. That is correct because some of the states had started to discard the common law at that point because of a discriminatory view that a woman's proper role was a wife and a mother, a view that the Constitution now rejects, and that's why it's appropriate to do the historical analysis at a higher level of generality. So she's saying they were really wrong then because of their view of women in the world, and it really didn't have anything to do with the fact of, you know, they were banning abortion when they knew the baby was there under the crudest of standards when we didn't have all this science. So then Alito he's smelling his way to the barn. And he's saying, in the face of that, can it be said that the right to abortion is, because their position is the right to, the pro-abortion position is, make no mistake, the right to abortion is deeply rooted in history and tradition in this country. That's a unbelievable statement to make. And so he says, in the face of all of this, in other words, the laws, there were no laws, the court decisions and so forth, he says, can it be said that the right to abortion is deeply rooted in the history and traditions of the American people? That's a tremendous question. So here's what she says. Yes, it can, Your Honor. Again, at the founding, women were able to end their pregnancy under common law, and in fact, this court in Glucksburg specifically decided, Casey decision talked about it, note 19, and so forth, and he says, what was the principal source the court relied on in Roe for its historical analysis? Who was the author of that note? And she couldn't remember, and so forth, and then finally he ends with, fine, thank you. So a lot of this is just probing and jabbing and see how, you know, the other party will respond. So that's Alito. Hopefully he'll go on the pro-life side. Let's go to the other side then. So Breyer, Stephen Breyer. Breyer and Sotomayor and Kagan have all publicly stated in decisions and otherwise that they believe Roe and Casey generally are good law. Okay, going back to 1992. So Breyer now is going to get the chance to question let's see who it is here. So he gets a chance to ask questions. And he is talking to the pro-abortion attorney, Julie Rickleman, who's for the chamber, and hold on, I have to find this, or I apologize. So he's talking about, he's saying, I'm afraid that if this court does this because of this consternation in the country right now about Roe and Mississippi and all these laws and things, that they'll look at us as not really doing our job, that we're just responding to the public pressure. And he says, and so he makes this speech. So this idea of, you know, we don't want to overrule these watershed cases, and just because we think that there's all this public pressure and so forth, and so Breyer says, and that's what kills us as an American institution. So he's waving the American flag. That's what they're saying. They're looking at it for that. But we're looking too, and they say the reason is, a reason why when you get a case like that, and he says this, and this is unusual in this setting, because this is very proper and formal. So, and some of the commentators notice, he says, when you get a case like that, where you're going to overrule a precedent like Roe, he said, you better be damn sure that the normal stare considerations about it being decided, stare decisis overrulings are really there in spades, double, triple, quadruple, and when they go through and show they're not, and then they go through and show they're not. So he's saying, okay, I'm warning everybody, if you want to overrule Roe, you better really be ready for that because the people aren't going to accept it. Well, we've had 50 years of legal scholars basically dismantling Roe and Casey and saying what a legally poor decision it was. Going back to what I said, in part because Roe said, oh, the states can restrict after viability and even prohibit abortion, but then in Doe v. Bolton, using the World Health definition of health, so what they appeared to give with one hand, they took away with the other. That's just legal madness, and that's what we've dealt with for 50 years. It's just unworkable. So, if you look back at what I gave you, Sotomayor, Kagan, Breyer, I think they're all going to vote to uphold Roe. Another thing you see in these oral arguments is Justice Sotomayor threw some softball questions to the attorney for the Biden administration. Let me find those. So sometimes they know that everyone's watching this and they know that someone's going to read this. And so she says, she makes a big speech. So she says this: it is certainly true that there could be some planning by some people about pregnancy. People who are raped don't have a choice, whether it's by an outsider or their own husband. And not everybody can afford contraceptives, contrary to your adversary's brief. In fact, 19% of the women in Mississippi are uninsured as they don't have money to pay for contraceptives. So, but why? Their point is, meaning the pro-lifers, their point is that, you know, contraceptives, if you use them, the failure rate is very small, et cetera, et cetera. How can there be real reliance? So she's saying, how can there be reliance by the population on Roe, which that abortion is entrenched? And so here's the question. She says, how would you address that issue? So she's teeing up a softball for this attorney. She's on conflict with. She says, how would you address that issue? So just give your speech, which she goes on to give a speech. And so then she says, you also mentioned, or maybe it was your co-counsel, life changes for women after 15 weeks. And then she gets to get another speech and so forth. And the other thing that Sotomayor says that's so intriguing, because the Attorney General for the state of Mississippi brought up the fact that in the last 30 years, we've had changes in science. They don't mention it specifically, but it's things like the 5D pictures that a whole generation of kids have grown up seeing their little brothers and sisters grow before birth. And so, and he also mentions the science of pain before birth. So here's what Justice Sotomayor says about that. She says, and so he's saying we've had 50 years of developments in science. So here's how she dismisses this, so just dismisses it out. She says, a small fringe of doctors believe pain could be experienced before a cortex is formed. And then she goes on to say, virtually every state defines a brain death as death, yet the literature is filled with episodes of people who are completely and utterly brain dead responding to stimuli. There's about 40% of dead people who, if you touch their feet, the foot will recoil. And so she's saying that person's dead. If they recoil, it's not pain. And so she's saying, so she simply, as one example, is dismissing scientific advances. Now, I wish someone here would have talked about how they're doing surgery on the unborn, and have been since, I want to say, the early 80s, that there's a Life magazine cover of surgery in like 1983. So this is nothing new. So she kind of dismisses out of hand the science of it. And Gorsuch, who's new enough that we're not sure where he might stand, and I hope this isn't boring everyone, but this is about the oral argument, and this is how you get there. So he says, so he's going to poke, now Rickleman has had her softball question from Justice Sotomayor. So Gorsuch, who we hope falls over on the side of the fence that decides to overrule Roe, so he's going to talk to Ms. Rickleman, the abortion chamber's attorney, and he says this: you said in your opening, your briefs say it's sort of your choice here, justices, is you got to overturn Roe or not overturn Roe. Okay? Well, he's going to say, do you really want that? Because if that's what you want, you're taking away any possible middle ground that's going to leave room for abortion in some states. So he says to Ms. Rickelman, he says, just to follow up on that, I read your briefs. Your brief to say that the only real options we have are to reaffirm Roe and Casey as they stand or to overrule them in their entirety. You say, quote, there are no half measures here. Is that the correct understanding of your brief? Because if it is, they're all in. And it's, you know, as you can see in this handout, there's middle of the road options they could take. They can overturn Roe and Casey, they could sort of do a hybrid, and there's lots of choices here, presumably, if they don't overturn Roe versus Wade and Casey. And so I'm not sure she was ready for that question, but she said, well, her answer was, Your Honor, it's certainly the arguments that the state has presented is what we're responding to there, which is that all the state's arguments, including their alternatives and such, they're saying, well, the state wants you to overturn, so we're saying we're responding to that. Well, you can respond in ways that don't include it's all or nothing. So he kind of exposed that bluff. And so I hope that he follows up on that. So that was kind of interesting. But these are the little nuances that you can see in the questioning that go back and forth between the attorneys and the justices. Let me see if I can find one on Justice Barrett, because she asked something, and they call her Justice Barrett, so I do too. Her name is Coney Barrett, obviously. But she asked, I think it was her, no, it wasn't her, it was, where do I have her? 109. Sorry, this is over 100 pages, so I had to find something. Oh, so the pro-abortion argument in part was that, number one, you have a right to abortion, and then you have a right to choose whether or not to be a parent. So Justice Barrett says, Coney Barrett says, well, we have safe haven laws. They've been around since the 90s, or 89, whenever the first one was passed. So people who, you know, what do you say to someone who says, well, it's really not a constitutional right not to parent, because we can solve that. You know, you can give up your baby. So she says to the attorney Prelagar, who is the Biden administration's lawyer, and think about that for a minute. So they get two bites of the apple. There's only two parties here. And there's a whole bunch of friend of the court briefs, they call them amicus briefs, there's probably dozens of those. I didn't check them all out, but there's hundreds and hundreds of pages of briefs that have been filed here. But the Biden administration, because it's the administration, gets to have a voice at the table. So it's really 2 against 1. It's Stuart Scott from Mississippi, then it's the abortion chamber's lawyer, then it's the Biden administration's lawyer, and then Stuart Scott gets to go, or Scott Stewart gets to go back. I keep confusing him with the deceased ESPN reporter. So Barrett says to the Biden administration's lawyer, and I mentioned the safe haven laws to Ms. Rickelman, and it seems to me I fully understand the reliance interest. There talks more about it, and then she says, but what do you have to say to the petitioner's argument that those reliance interests do not include reliance on parenting and bringing the child in the world when maybe that's not the best thing for her family or her career? So she's really kind of saying, you know, what about safe haven? And so this pro-abortion Biden administration lawyer says, the analysis goes wrong when they're overlooking the consequences of forcing a woman upon her choice of having to decide whether to give her child up for adoption or not. That itself has its own monumental decision for her. So what she's really forced her into saying is, this really isn't about the right to abort. It's not only the right to abort, but if someone would say, give us, as we're saying in society, with 2 million people out there waiting to adopt, give us that child. Give society, give this country that child, and if you don't want your child, go to the fire station, go to the hospital, we'll take care of that child. She says, no, and basically your answer is, no, it includes that too, because you can't force someone to give up. So we want the right to kill, we want the right to take away someone else's right to adopt, or to even have a chance for this child. So these little nuances are very interesting, at least to me. So I hope that isn't boring, everyone, but the sum and substance of all of that is, oh, and then lastly, Kavanaugh. let me see what he said. So Kavanaugh, who's new to the court, he wants to ask them questions about, can't we decide that the Constitution, Roe was wrong, Casey was wrong. The Constitution doesn't say anything about abortion. The Constitution and the 14th Amendment don't say you have a right to privacy. So some might argue credibly that the Constitution and the 14th Amendment are abortion neutral, okay? And the 14th Amendment, in fact, he doesn't say this, but you could argue it's pro-life because you can't deprive of life, liberty without due process of law, okay? So he says to Mr. Stewart, and this is, let's see here. It's kind of a softball question, all fair. He says, and to be clear, you're not arguing that the court somehow has the authority itself to prohibit abortion, or that this court has the authority to order the states to prohibit abortion, as I understand it, correct? And the Attorney General for Mississippi says, yes, correct. And he says, and as I understand it, you're arguing that the Constitution's silent and therefore neutral on the question of abortion. In other words, that the Constitution's neither pro-life nor pro-choice on the question of abortion, but leaves the issue for the people of the states to, or perhaps Congress to resolve in the democratic process. Is that accurate? And Stewart says, of course, right. We're saying it's left to the people, Your Honor. And so Kavanaugh says, and so, if you were to prevail, the states, a majority of the states or states still could, or presumably would continue to freely allow abortion, many states, and some states would be able to do that, even if you prevail under your view. Is that correct? And he says that's consistent with our view. And Stewart says to have the full voice of the states, they're going to do what they want, and that's the way it should be, left to the people. And then Kavanaugh says, thank you. So the oral arguments in summary are kind of a way for the justices to make their points publicly, so that when they join or write an opinion, someone can say, well, that makes sense with what they've said before. And to air publicly, because all the media is there reporting on all this and so forth. And when you think about it, with the hundreds and hundreds of pages of briefs and documents that get filed with the court, to have a 2-hour argument would never do it justice. You'd have to have a 2-day argument to fully explore all these things. So, I have more to offer, and I'm going to do that and then take some questions. So it's hard to say state by state what would happen depending on what happens in this decision. I will offer a few thoughts. If Clarence Thomas, the longest serving current justice on the Supreme Court, writes the opinion, that can only come if he's comfortable with whatever majority is. And my belief is if he authors the opinion, it would be the culmination of his 30-plus year argument that Roe is wrong and the time has come. And I think that would be his well-deserved legacy as the author of that opinion. I would expect that would come in perhaps a 6-3 decision, more likely a 5-4 decision. And I don't think that will happen, of course, unless Alito, Gorsuch, Kavanaugh, and Coney Barrett join him. Those would be the 5. The 3 adverse would be, well, it could be a 5-3-1. So it could be those 5, and then Kagan, Sotomayor, and Breyer with another view, and then the last one is Chief Justice Roberts. So I haven't counted too many there, have I?
No.
So, all right, okay. So there's your math. Now, as you can see on the handout, go to the very bottom, they have some choices. And this isn't my original, I've taken this from readings I've done, and this is a chart put together by others. So one is the Supreme Court overrules or overturns Roe v. Wade and sends it back to the states. And as you've seen in some discussions, 18 states immediately ban abortion because they have trigger bills, the trigger being the overturning of Roe, that their state law protecting the unborn would go into place. And then there's 22 others that 18 states immediately banned 13 states in DC recognize the right to abortion, so it's 18 to 13 and 22 others, we don't know what they're gonna do. Then the middle choice is that the Supreme Court allows states to prohibit abortion before viability. It's kind of what we have now, but moving it down to pre-viability when the state does not do a burden of substantial number of people seeking care. That's that undue burden test. How many abortion clinics, how poor are people, how far do they have to travel, etc. And that's the thing that's been a mess for 50 years. And the last one is, of course, the one we prefer not to see. They uphold Roe v. Wade and just, say, bring us more cases. And I think that would be a disaster. So let's talk about Iowa. In the last box in your handout, in 2018, unfortunately, the Iowa Supreme Court used a case that came before them. I want to say it was a 72-hour waiting period case to find a right to abortion in the Iowa Constitution. And that is an extreme and terrible result. And so what that means is, if Roe is overturned in Iowa, abortion clinics could still freely operate because the Iowa Supreme Court has determined that a woman has a right to an abortion in Iowa under the Iowa Constitution. And unless the state constitution conflicts with the federal constitution, which it wouldn't if Roe is overturned, and it doesn't now because Roe is the law of the land, then the federal courts don't get involved, and the Iowa Supreme Court is the last determiner of what the Iowa Constitution means. So we're stuck right now. And toward that end, in the last legislative session, the Iowa legislature passed what's become known as the Protect Life Amendment, which I've repeated there. It passed in the spring of this year. It has to sit out 2022 because there has to be an election. Pardon me. So it has to pass twice in legislative sessions with an election in between. So it'll be up again in the spring of 2023 for passage and then put to a vote of the people. It's a long process, and the reason is you don't want to be able to amend or change your state's constitution without a process that time-wise shows that the people support it. So presumably having a legislative election in the middle, pass the amendment, which they did. Now we're going to have election. Let's see if we elect pro-life people or pro-abortion people. Elect pro-life people, and it's going to pass again. And then if that isn't good enough, then it's going to come to a vote of the people in hopefully in the fall of 2023 then. Or maybe 24, I'm not sure of the schedule, but hey, it's passed once, so now we have to have a legislative session where it's not considered, then an election, then they'll consider it again. So the next time it gets considered is in the legislative session in the spring of 2023. And so I've repeated the amendment there, Protect Life Amendment in Iowa, to defend the dignity of all human life and protect unborn children from efforts to expand abortion even to the point of birth. We, the people of the state of Iowa, declare that this Constitution does not recognize, grant, or secure a right to abortion or require the public funding of abortion. Just makes the Iowa Constitution abortion neutral. And along the lines of what Scott Stewart said in his opening, give it to the people. Let the people decide whether unborn babies should be killed, how we protect women in crisis pregnancies, and how we help them. I'd offer one final comment that I think will need to go with all of this. I think no matter what happens, the Dubuque County Right to Life has to continue its educational efforts. I think Dubuque County Right to Life has to educate on the Protect Life Amendment. I think we have to continue to offer positive pro-life answers to crisis pregnancies for women in distress. And like the state of Texas did in legislating $100 million to go along with their fetal heartbeat 6-week ban on abortion, we need to provide money and help and education and counseling and support to women and show them that the reasons they choose abortion don't exist in the state of Iowa. There's help. So if you're choosing abortion because someone's pressuring you, we can protect you. If you're choosing abortion because you don't have money, we can help you. If you're choosing abortion because you can't finish school, we're going to help you. If you're choosing abortion because you don't have a place to live, we'll help you. If you're choosing abortion because someone wants you to have an abortion and you don't, we'll help you. If you're choosing abortion because you don't think anyone will adopt your child, we'll explain why that isn't true. And along that whole journey, We'll help you with aid and support and comfort and everything you need. And if we do that, in my view, it's a two-pronged educational effort. It's support, it's education, it's putting our money where our mouth is, and I think the American people are ready to do that. And I think it's sad that 50 years later and millions of deaths later of unborn children and women being hurt, it's time to change that. Hopefully the Dobbs case will do that. If it doesn't, we fight on. If it does, then we act in Iowa and other states in conformity with getting that pro-life message out there. So, I tried to leave some time for some questions. I hope that made sense. And as you can tell, I enjoy talking about this because I think it's the most important civil rights issue of our time, and I think it has so many parallels to slavery and how it took 100 years and more, generations to solve slavery. And in the same way, I don't know if we talked about this before we started, imagine if they had oral arguments in the Dred Scott case and outside slaves were being bought and sold, and in the privacy and the decorum and the regality of the Supreme Court, they're talking about whether Dred Scott was a piece of property or a human being. It's just, we look back at those times and we think how savage and how immature and how wrong and how unreasoned that all was. And I'm convinced that someday they'll look back on this time, a period of time in our history, and see the same thing. How could they have done that? How could they have done that? And there were people, fortunately, that tried to change it. And that's us. So that's it. Thank you very much for your attention.